everybody, welcome to the Supreme Court Observer. I'm Gauri Kashyap and today I have with me Justice Sapana Malla of the Nepal Supreme Court. Thank you for being with us here today, ma'am. I have a few questions to you about your experience as a judge and about some of the learnings that both our jurisdictions can have from one another. Let's start at that point. You said your education was in India, you were in the Delhi University, and so you've studied the law from here and you've had an extensive experience in Nepal in the legal field. What are some of the learnings of the two jurisdictions?
First of all, learning social action litigation from Professor Baxi, which we took back to Nepal, and that was quite instrumental in creating accountability, especially challenging the law, which was problematic for women. Other than that, the jurisprudence developed by Supreme Court for years and years has inspired many of our judgments, because you have one constitution and you have expanded the constitution. You have gave constitution life through the interpretation, expanding many rights, which is a very good learning for us, because Nepal, we have with every political change, we have a new constitution, so we have not been able to mature the constitution, whereas now we have an opportunity, because the new constitution was made through the Constituent Assembly, and the new constitution has even created a space for us constitutional activism. We don't even have to do the judicial activism. So much learning with how judiciary has been functioning, and because the education process, almost how law was enacted in a similar context.
Often in the body of the work of the judiciary, it's crucial that it remains independent, so as to not go head to head or enter the domain of other pillars of the constitution. What are some of the challenges you faced in your jurisdiction with maintaining the independence of the judiciary?
See, of course, there is a separation of power, but there is also check and balance. So the constitution has given responsibility to judiciary to check the executive action, and so what we are doing is the constitutional functioning. Of course, we have to keep restraint, but and again, like in Nepal, the whole appointment process of Supreme Court judges is so political, but judges and the court has been maintaining independency through its decision, and lately two judgment on Parliament dissolve is a vibrant example of how independence of judiciary is functioning in the country.
In India, the counterpart, we have the collegium system. What are your comments on that model of judicial appointments?
There are both side argument, because here we are saying, because there is a minister, there is a prime minister representative in a judicial council, we have a chief justice and senior most judge, and we have a law minister, and bar representation, so it's a 5-person council. We feel like depending on the how they function, but to maintain the independence of judiciary, it is better that we have a collegium.
So you have a vibrant body of work in women's rights, and you've both as a lawyer prior to that as well, and as I'm sure you've carried some of that to your career as a judge as well. And diversity in the judiciary is a very often debated issue, and I think there are several stages at which that diversity can be brought in. So what are some of the key actions we can take?
Representation of diverse group is critical, because the experience of different suffering, putting our feet on the shoes of excluded group, marginalized group, disadvantaged group is critical. Representation matters. And therefore, I think from the law faculty, law school, from the education, we have to start how to make sure that diverse groups are represented in the school, in the college. For example, in Nepal, we have a limited women judges, we have a limited women lawyer, but what is hope we have is like right now in the law college we have 70-80% women. If you look at the examination, like they are the top 10, Bar Council top 10, so we have a hope. But then the challenge what we are finding in Nepal is high dropout of women after they come to the profession. So how to sustain them in the profession is a key challenge.
What are some of the struggles you faced? Because you've now, that dropout level, you've crossed that and you've entered the judicial profession. What are some of your experiences and what can we do to encourage women?
No, I think what we as a state organ, we need to create an enabling environment because women are equal but they are different. They are different because of the social expectations, social construction. They are different because they have a different reproductive functioning. So, and as a result, there is a huge disparity. So we need to recognize that women's reproductive functioning is a state functioning. It's not only for her. And to bridge the disparity, diversity has to be recognized, inclusion has to be made, but inclusion along with the empowerment, because inclusion can create an enabling environment, external environment, bring the policy, but empowering internally is critical. So I think if we can have some special measure with this approach, representation can be ensured.
In the sessions earlier, you mentioned that you feel an added expectation from you as a woman judge. Can you tell us a little bit about your experience?
No, I mean the added, the different expectation is because I have been working for like 20 years on women's rights. I was a women's rights activist, but that doesn't mean when you are a judge, you have to ensure impartiality, fairness. Of course, I'm a gender sensitive. Gender sensitive does not mean I'm against any sex, any color, any religion. So bringing that sensitivity is key. But still I cannot be prejudiced. So that expectation is a challenge because I cannot be blind. I cannot ignore the fact of the case. Secondly, also I'm seen as a threat because when I'm in a bench, they think, oh, I will be always in other side. It's not that. So changing that perception and challenging that expectation is critical for me.
So to sort of recenter the expectation from our judges, oh, this is a woman judge and therefore she will judge in a certain way.
Yeah.
And to say, no, this is a judge.
Yeah.
And they will behave in a non-partial, fair way. You also mentioned that in your work you've changed over 100 laws in Nepal. Just through the public interest litigation jurisdiction of the court. In India, VILs are widely celebrated and used in many ways, but it has received some criticism for opening the court's doors too wide, which means that the court's docket is suffocated and it's not able to function as effectively as you can. What are your thoughts now?
I mean, this question has also been raised in Nepal now. But when we initiated the case, we did not come only, just for the sake of PIL. Because before doing PIL, we did a detailed research of, we did an audit of law that is discriminatory. And we did not only look at the facial discrimination, we even looked at the weakness and gaps and how that law is impacting on women in society. So I think that evidence-based research and evidence-based legal advocacy at the court made the difference, because my most challenging case was marital rape case. They said we are challenging the marriage institution, we are being against religion, but the truth is that everyone has right to say no, because even in marriage the relationship has to be consensual. So finally, the court says rape is rape, no matter who is rapist. Even her husband cannot get exempted from the punishment, and then now there is a law in place.
How do we then ensure that frivolous petitions don't go to the court? Because you said rigorous research is required and a lot of data-based and strong petitions need to go into the court. But often frivolous petitions go into the court and maybe even give PIL a bad name. How, from the judiciary's point of view, from the bar's point of view, how do we tackle that issue?
One is like, I think in the PIL also there is some interpretation, some jurisprudence has been made, how, there has to be a substantial relation, substantial interest who is filing the case. I mean, we have to be very careful while registering the case itself in the court. So you have to check from the registration, and even when the matters comes before the bench, we need to carefully examine the interest, why the case has brought, what interest has, what is the interest behind those cases. So I think we need to be very, very careful in examining those kind of matters.
Is there, do you think, any value in penalizing frivolous petitions? Or would that discourage people from accessing the court?
I would not say, because penalizing may discourage. Penalizing can be misused. So rather than that, scrutiny need to be created, and educational program has to be launched.
Well, thank you so much for your time, and thank you for such wonderful answers to our questions. That is Justice Sapana Malla of the Supreme Court Observer. Thank you.